We'll be starting in just 1 minute. If anyone has any additional issues with getting the error message, please look along the top of the screen and you'll see the third tab from the left, the very last tab, says Stalking and POs. Go ahead and click that tab and it should take care of your error message. Good morning. My name is Sarah Henry and thank you for joining us for the National Center on Full Faith and Credit's webinar on stalking and protection orders. NCPO-FFC is an OVW-funded technical assistance provider. The views expressed by the presenters are their own and not necessarily those of the Department of Justice. NCPO-FFC is pleased to welcome Michelle Garcia, Director of the Stalking Resource Center, and Marc Guillory, Assistant District Attorney for San Francisco. If you have any questions, please type them in the chat and we will try and get to them at the conclusion of the presentation. Marc, Michelle?
Good morning.
Good morning.
Please go ahead and begin.
Great. Thank you so much, Sarah. We appreciate the opportunity to talk with everyone today about stalking and protection orders. Marc and I are both going to trade off throughout the presentation, and please, folks, feel free, if you have questions, ask those in the chat section. Sarah will be monitoring those, and we will hopefully be able to answer all of your questions either during the session or offline after the session. Where we want to start today is really establishing a foundation as we move forward throughout the rest of the presentation, and that is by defining what is it that we're talking about when we're talking about stalking. Our working definition for this session is going to be that stalking is a pattern of behavior directed at a specific person that would cause a reasonable person to feel fear. Now, you'll probably notice this is not a legal definition because it is very simple and easy to read, unlike many of the stalking statutes across the country. But this is going to guide us in just a few things about this definition. First, that stalking is a pattern of behavior that occurs more than one time. And in fact, the majority of statutes across the country are written with language that indicates it has to be behavior that happens more than once or on at least occasions, or in one state on at least 3 occasions. We are talking about this repetitive behavior, and that's going to come back into consideration as we talk about protection order violations as stalking behavior. When we're looking at stalking behavior, we also have to keep in mind that context is absolutely critical in stalking cases. When we look at stalking as a crime, we have to shift our paradigm in how we approach this compared to other crimes, because we're not looking at an incident-based crime. We're looking at a course of conduct. And so we have to look at that full pattern of behavior, and we have to understand the context of how and when it's occurring, and also what that behavior means to that victim. Because fear is a very subjective thing. We're all afraid of different things. What may seem terrorizing to one person, we can't quite understand. There are behaviors that an outsider might see that make that victim fearful, but that we don't understand. So often what's required is putting oneself in that victim's shoes to understand what that behavior means to them. So how common is stalking as a crime? How likely are any of us to encounter this in working with victims or working with offenders? And so I'd like to ask you that question. How many people do you think are stalked every year in the United States? If you could indicate your answer using the chat function on the left, typing in either A, if you believe it's less than 5,000 people, B, if you believe it's 1 million, C, if you believe it's 2.6 million, or D, if you think it's 3.4 million. So if everyone could just take a moment and use the chat feature on the left and type in your answer to how many people do you believe are stalked every year in the United States. And we'll just give folks a minute to do that. All right, I see people are answering. We're definitely getting a range of answers here.
Wow.
All right. Great. And people feel free to continue answering. I will let you know that the correct answer is D, that 3.4 million people are stalked every year in the United States. Now, where this statistic comes from is actually from a report called Stalking Victimization in the United States that was published by the Bureau of Justice Statistics in 2009. And this was based on research that is part of the National Crime Victimization Survey. This was actually the largest random sample national study of stalking ever done to date. It is really one of the best comprehensive pieces of research we have on stalking in the United States. And what they found was that in a one-year period, 3.4 million people are stalked each year. Now, a couple things about this. The study only focused on adults, 18 and over, and so we know based on our experiences, and many of you know based on your experiences as well, that stalking is a behavior that doesn't just magically start when one turns 18, but we're seeing this behavior more and more commonly around younger populations, high school students, middle school students, and so when we think about the actual rates of stalking in the U.S., it's probably much higher than 3.4 million people if we count adults and non-adults. So there's a great likelihood that stalking is happening in your community because when we look at how that rate breaks down, for every 1,000 people, there are 14 cases of stalking. So if you want to find out the statistical rate of stalking in your own community, take the population, divide it by 1,000, and multiply by 14, and that's the number of stalking cases happening. And then my question to you is, are you seeing those cases? Are you working with those victims? Are those victims accessing services? Are they reporting to law enforcement? Are you seeing those cases within the criminal justice system? Are those victims getting orders of protection? And I think overwhelmingly across the U.S., the answer is no, that most victims still are not accessing resources, reporting to law enforcement, getting orders of protection, and getting the assistance they need. And we'll talk about some of the challenges around the criminal justice piece as we go throughout the session. When we look at who are our victims of stalking, we find that both males and females can be victims. However, females are nearly 3 times more likely to experience stalking. We are seeing increasing numbers of male victims as well. Conversely, when we look at who our offenders are, most often offenders tend to be male. However, we are seeing increasing numbers of female offenders as well. Because the reality still tends to be that the majority of victims are female and the majority of offenders are male, I'm going to tend to use language to reflect that reality throughout the presentation, but I don't want to discount the reality that males can be victims, females can be offenders as well. And when we look at the relationship between victims and offenders, what we see is that in the majority of cases, the victim and the offender know each other in some capacity. Very rarely, in only about 10% of cases, are the victim and offenders absolute strangers to each other. They're going to know each other somehow. They're going to be friends. They're going to be neighbors. They're going to be acquaintances. Perhaps it's the person who delivers your mail or checks out your groceries at the grocery store. They can be coworkers. They can be relatives. Most often, however, it will be a current or former intimate partner, so boyfriend, girlfriend, spouse, ex-boyfriend, ex-girlfriend, ex-spouse, which shouldn't be too surprising then when we start to see this connection between stalking and domestic violence, stalking and intimate partner violence, and this is where the protection order comes into play, because when we look at instances where there is that relationship, there's often this history of domestic violence, and so in many of those cases, we will see victims who do get protection orders. But even in cases where that isn't a previous relationship, we are seeing protective orders as well. And that's because when we look at the type of protective orders that are available to stalking victims, we see a couple different options that vary from state to state or territory to territory. So in all jurisdictions in the U.S., some form of a domestic violence protection order is available. And in many jurisdictions, if you look at the language under that legislation, it incorporates stalking behavior, so that type of repetitive contact, repetitive harassment, or threatening behavior. However, typically in these types of orders, there is an element that restricts who can access them based on the relationship between the victim and offender. In many cases, the type of language is that they had to have been married or have a child in common or shared a household or had a previous dating relationship. And so not all stalking victims would qualify for a domestic violence protective order. Many states, recognizing this gap, have passed legislation enacting separate or standalone stalking protective orders or no contact orders that allow anyone experiencing the behavior defined as stalking to access a protective order regardless of what their relationship was. And then in other jurisdictions, we see other types of no contact or restraining orders that may be available to stalking victims as well. So depending on your jurisdiction, there may be different options available to a victim who's experiencing stalking in terms of finding some sort of civil relief. Now, when we look at the rates of obtaining protective orders, the Stalking Victimization in the U.S. survey asked victims whether this was an option that they had pursued. And what they found was that about 16% of stalking victims obtained some sort of protective order, whether it was a restraining or protection or a stay-away order. So we are seeing some victims who are accessing these types of orders. But I have a question for you again. Do you think that protective orders stop stalkers? So I'd like you to indicate whether you think this is a true statement or a false statement, again using the chat feature on the left. So true or false? Do protective orders stop stalkers? All right, we see folks answering, and it looks like overwhelmingly people believe that this is a false statement. And in fact, in most cases, protective orders don't seem to stop stalkers. Again, when we look at the Stalking Victimization in the United States report, when victims were asked, had the stalking stopped, and if so, what do you believe caused the stalking to stop, about 10% said that it was a restraining, protective, or some sort of no-contact order. However, within that question, they were able to check multiple responses. So they could have answered talking to police as well as getting a protective order, or moving away and getting a protective order. So it's very difficult to isolate, was it specifically the order that stopped the offender, or was it the order in combination with something else? So in a small number of cases, we do see protective orders having an effect in stopping the stalking. However, we also know that most stalking protective orders are going to be violated. Both for female victims and male victims, there is a great likelihood that the offenders are going to violate the protective order. And when we look at how offenders violate protective orders, we see it happening in a broad number of ways. That in many cases, the offender will make direct contact with the victim. They will call them, they will text them, they will email them, they will show up at their home, at their workplace, at the grocery store, at the gym that the victim goes to. And so direct contact is probably one of the most easily recognized types of violations of protective orders. Keeping in mind, we have to think about technology these days and how often technology is used to communicate and to contact folks. We can see offenders who will steal items from the victim. So they won't necessarily make direct contact, but they'll break into her car and they'll take something, or they'll take something from her home or outside of her home. They'll do damage to the property. Vandalism to the car is the most common form of property damage we actually see in stalking cases. In a number of cases, threats are made to pets or actual harm is done to pets. And then in cases, particularly when there are children in common between the victim and the offender, we often see children used as part of that repetitive stalking behavior, that violation behavior. And often the use of children legitimizes some of that contact. So we have seen cases where, as part of a protection order, where there has been stalking involved and there's children in common, written into the order is language to the effect of the offender cannot have contact with the victim except to discuss issues around visitation or custody or child care. And you'll have offenders who are calling the victims 100 times a day or more, and then when the victim does report, their response is, but every call was to discuss something about child care, which is clearly an extreme example. But we'll see offenders use children to legitimize or try and find ways around language in protective orders. We also see other behaviors that are stalking behaviors that are part of violation patterns. So where an offender doesn't necessarily have direct contact with the victim, but will do something like place a GPS tracker on her car, without her knowledge, and so now the offender can track everywhere that victim goes without the victim knowing. Sometimes because they may take the order seriously and no longer directly contact the victim, they will start targeting people around the victim, so friends or family members of the victim, or even sometimes those of us who work with victims. We've seen cases where law enforcement, prosecutors, advocates, even judges, people who have been part of this case trying to hold this offender accountable, become targets of that offender. We'll see offenders using the legal system, so not only in cases of custody, but also if there's other family court proceedings, divorce, trying to manipulate the system in order to have that contact and work around that protective order. And then you'll have offenders who, because they are concerned about future consequences, may actually themselves stop engaging in the stalking behavior, but start enlisting other people to assist them with their stalking. Sometimes these third parties don't even necessarily recognize they're being used this way. So you may have an offender who calls a neighbor of their former partner and says, you know, I'm just worried about this person. I want to make sure they're okay. They've been having some trouble at work. Can you let me know, did she get home okay from work today? Is her car in the driveway? And the neighbor who thinks they're doing a good thing, a friendly thing, a helpful thing is now giving the stalker information, but not recognizing that's what they're doing. In some cases, they'll enlist family, friends, other people who know well that what they're doing is problematic and are intentionally furthering this offender stalking behavior. And this third-party stalking or stalking by proxy is fairly common. In fact, the majority of intimate partner stalking victims report that others were involved in the stalking, so that the offender did engage other people in assisting with the stalking behavior. We also know that this is behavior that can last for a very long time, that we see stalking lasting from a range of anywhere between 6 months to more than 5 years. The average tends to be about 2 years, but we know that these can go for a very, very long time. I recently was talking to someone who works with elder victims of crime, and she was telling me about a victim that she was working with who had been stalked by the same person for over 50 years. This was a person who went on a date with the offender one time in college over 50 years ago, and this person continued to show up in her life on an annual basis. So these cases are often long-haul cases that take a lot of time, a lot of energy, and often a lot of resources. And it's because these offenders have high rates of recidivism. These are offenders who don't take no for an answer, and in many cases don't care what the system says. So in the majority of stalking cases, we do see recidivism, and when we look at the time between intervention and recidivism, it's a very short period of time. And when I say intervention, I mean some sort of criminal or civil justice intervention. So they've either been arrested or they have been served with an order of protection. The majority of offenders, after arrest or after service of an order, will re-engage in the stalking behavior, most often 1 day later. 1 day after being arrested, 1 day after being served, they are right back at that behavior, which is why it's really critical we start looking at protection order violations and thinking about how we can also prosecute those as stalking behaviors, because we know these offenders often pose a great risk to their victims. Marc, I'll turn it over to you.
Thanks, Michelle. This slide is one of these slides I always try to talk about. And if you read it, it pretty much makes sense, and it falls right into the crime of stalking. Some people who make threats ultimately pose threats. That's why we criminalize threats. But some people who make threats do not pose threats. But threats are still criminalized for the realism and the potential of acting upon the threat. And then some people who pose threats never make threats. And this, I'll put this slide in here. It's from either a CIA or FBI training manual. And what it kind of encapsulates is that basically you don't know what the stalker is going to do other than what the kind of behavior that they're exhibiting. So I kind of wanted to put we kind of wanted to talk about some cases just to provide you guys some examples of different kinds of stalkers and the kind of behavior they exhibited and the fear that they caused the victims. And People versus Eric Hoover was a case that I prosecuted and I believe about 2007, all the way to actually the present. He's in custody right now for violating a restraining order, not for protecting the victim, but protecting the victim's old law firm. She became an attorney in 2003, and from 2003 all the way up to 2 years ago, that was a loud beep. From 2003 all the way to 2010, he was communicating with her, and like Michelle was talking about in some of your the question was whether protection orders stop stalkers. Well, and most of you answered false. This is a case in point. She had a protective order after about 1 year of being stalked and harassed by the defendant. After the protective order, he sent her an email threatening to chop off her head, piss down her neck, and make her gasp. Those are, quote unquote, his exact words. Even while the criminal case was pending. This is a little bit outdated. He's not currently incarcerated in Napa anymore. He got out, but he's going back because there's a mental health issue with him as well. But that's just one type of stalking, and basically the victim in that case, she's still scared to this day. I check in with her from time to time to let her know what the status of the case is all the time, and it's just severely affected her life. Her whole career as an attorney has been being stalked by Eric Hoover, and even now he's having contact or having inappropriate contact with her old law firm, which is the only area that he's restricted from contacting at all. And it goes to that case kind of illustrates the premise of access and proximity. And the reason why I like to talk about access and proximity is because most people who engage in stalking behavior, they engage in a process of access and proximity. It's important for victims to know this as well. The access and proximity kind of go hand in hand, and they kind of play off each other. So the more access a stalker might have, the less proximity he may need. The less access the stalker may have, the more proximity they may need. So a lot of times in some real cases, I suggest to victims, if they have a cell phone and there's incessant phone calls over and over, I don't necessarily, in my case, from my advice, from my experience, I don't necessarily tell them to cut off the phone. I tell them to get another phone and use another phone to contact friends, family, and engage in normal communication, and let the person who's harassing them leave messages and call that phone that's pretty much inactive but still operable, so that that access is still there, so that if the phone is cut off, they're not trying to come by the house or come by the workplace or anything like that. So that's some of the real advice that I give victims in some of my cases. Now, whether it's up to them whether they follow it or not. But I just think in some of the cases that we've handled in San Francisco, it's just worked out that way. And it's an important thing to remember too. Always remember that stalkers need access and proximity, and how those two interplay. And I got that principle actually from Dr. Chris Mahandi, who does a lot of work in stalking and psychology. The main premise of law enforcement, or the mission statement, so to speak, of law enforcement is that the mechanisms are critical components to keep the women safe and hold offenders accountable. We as law enforcement have to hold offenders accountable for stalking behavior, even a violation of restraining orders. I see plenty of cases that come through our court system where there are multiple violations of restraining orders in intimate partner relationships. And time and time again, I tell some of our younger attorneys, file the stalking case, because that's what's happening. You have a person that's been directed by the court to stay away from a person or stay away from a location where a person either works or lives, and they keep on violating their restraining order. That's a red flag, and the red flags mean danger. It means that there's a danger amounting, and stalking does not get better, or stalking does not just stop by itself. It's a form of power and control, and until the stalker gets what they want, which is the attention of the victim or the person that they're preying on, they're not going to stop. So law enforcement and our resources are critical mechanisms to stop stalking conduct and hold offenders accountable to, say stop it, and if you don't stop it, you're going to go to jail. And sometimes keeping a person in jail is the only way to stop it, and that's what we have to do. And this is from one of the studies that Michelle was talking about, and it's important to recognize that the purpose of stalking prosecution and the whole effort that we're making here is to prevent homicides. And some of the Department of Justice studies show exactly what we're talking about. These are harrowing statistics right here that are based upon real cases. 76% of intimate partner murder victims had been stalked by their intimate partner. 89% of female homicide victims who had been physically abused had also been stalked in the 12 months before their murder. So we're talking about victims of murder, and we're also talking about them being 89% of them who had been abused had been stalked before they were murdered. 79% of abused female homicide victims reported stalking during the same period that they were abused. That's an important statistic for law enforcement and advocates, because what that is telling us, that 8 out of 10 stalking victims are saying, hey, I'm in trouble here, before they are victims of homicide. That's very important for us to realize. And then the last statistic is even worse. 54% of female homicide victims reported stalking to the police before they were killed by their stalkers. So of those victims that were killed by people that were stalking them, half of them reported that they were being harassed or bothered, or there was some kind of obsessive behavior going on before they were murdered. That's a very important statistic. That means they're checking in with us. 5 out of 10 are checking in with us, and that also means that having awareness and recognizing the kind of fact patterns that amount to stalking behavior can prevent actual homicides. People versus Delmar Palomo was a jury trial that was conducted in March of 2008 to April 2008. There was a dating relationship. The victim and the defendant lived together for 2 years, and she found out, actually it's a pretty nice fact pattern, she found out that not only did the defendant, not only was he married and had a wife in Mexico, but he had a girlfriend in Oregon, and she kicked him out of the house. Well, and there's also abuse that was going on during the relationship. It turns out that she was a victim of spousal rape during the relationship, and there was other characteristics of abusive behavior during the relationship. When he got kicked out of the apartment, he started making incessant phone calls. And at one period, during a 46-day period, he made over 240 phone calls. And the time period of the phone calls were between 11 p.m. and 5 a.m. The content of the phone calls involves threats. He had broken into her house on multiple occasions. On one occasion that was charged, he did rape her, the victim, and on the second occasion he attempted to rape her, but she fought him off. There were also multiple violations of a protection order. One actually involved a Good Samaritan trying to step in and protect the victim, and the defendant attacking the Good Samaritan. And the reason why I put cell tower engineering is because that was one of the techniques that was used during that time period. It wasn't new, but it was the first time, one of the first times our office had used cell tower engineering. And what that means is, I got an interesting thing. And this slide shows where we got the phone calls. This is Metro PCS, and I had Metro PCS color code all the phone calls that were made from the defendant's cell phone to the victim's cell phone and the time period. And if you look all the way to the right-hand side, there are codes. Those codes are significant because they identify a certain cell tower. And how cell phones work is that, the reason why you have 5 bars is because you're connected to the nearest cell tower there is. So when you make a phone call with full bars, you are pretty much near a cell tower. Depending on the time of day, you will connect to the nearest, most available cell tower. So for instance, you could be near a cell tower that you should have 5 bars to, but because there's a vast amount of traffic at 12 o'clock in the day, it might direct you to a cell tower that's further from you. So you might have 4 bars now. But at 12 o'clock at night, at the same location, you'll have 5 bars. And the reason why you have 5 bars is because you're at the nearest, most available. So we were able to track him, and a lot of these phone calls were coming up. He was making these phone calls in violation of the protective order right outside of her house, because she had a cell tower that was about within a block from her house, and he was making these phone calls right outside of her house. And the irony is that when he testified and admitted that he was making the phone calls, which was in violation of the restraining order that says no contact, no direct or indirect contact, and also to stay 150 yards away from her home. Well, he said one of it wasn't very humorous, but one of his attempts at humor was that he said that he was actually, when he made the phone calls, he was 150 yards from her house. And you can imagine the cross-examination there. I just let that one go because he admitted the phone calls but somehow was cognizant of being 150 yards away. It didn't make any sense, and obviously he was convicted of 2 counts of felony stalking and over 30 violations of the restraining order, which I also charged, because stalking is a very difficult case to prove, and that's why we have these kind of trainings. They also convicted him of the lesser offense to the felony charge of assault with the intent to commit rape. And I just want to say this: the victim was very upset about that because she felt she was sexually assaulted, and that was the most important charge to her. Basically the jury said, we believe that something happened, but we don't think there was enough proof that there was a sexual assault, which is that's the tough part about spousal rapes or dating sexual assaults, is that you don't have that kind of forensic evidence that you would generally have on a sexual assault case. He was also sentenced to 3 years state prison and also deported and excluded from the United States. That's just another case profile that it's an alternative, or not just an alternative, but different kind of facts, but similar conduct to the People versus Eric Hoover fact pattern that I discussed a little bit earlier. People versus Gloistein was another case that we prosecuted in 2009. This was a prior dating relationship. And by the way, if anybody has any questions, or just go ahead and chime in. That's okay with me. Is a dating relationship. This one was an interesting case. It was a prior dating relationship, but in this case, the victim wasn't as cooperative as the 2 prior victims were. She was a victim of domestic violence, and it was an early. They're both these. She was pretty much a kid. She was only 20, 21 years old. He was the defendant was I think about 24 years old. But there were significant domestic violence incidents. He broke her nose in March of 2009, and she moved out of the house. They both lived together, and well, when he's trying to get back together with her, he offered to paint her new apartment, which he did. But at the same time, he made a copy of her key. So on one of these days, when she was broken up with him, he was calling over and over, again, incessant and unreciprocated phone calls and text messages, very angry. He was intoxicated, threats to kill, both direct and indirect, and he basically broke into her home. And one of the more eerie parts of this fact pattern is that after she was getting all these phone calls from his cell phone to her cell phone, the one phone call that made her the most scared was the phone call she received from her own home that evening. That's what made her call the police. Also, at one point, he threw her puppy into the street, and he held her against her will in the home. There's obviously a history of domestic violence. And one of the eerie moments of the fact pattern is that the victim's friend, she was with a friend in this case, and she had the friend had another friend who was a police officer, and asked the police officer to go to the home after they received the phone call from her home, which scared her. Well, the defendant texted her back, "Why are you sending the police to your home?" while the police officer was in the home. So what I try to explain to law enforcement officers are, stalking calls are just as dangerous as any other kind of call, especially any kind of domestic violence call. Obviously, we know that those are pretty dangerous calls for response. But the stalker was looking at the police officer going to the home. That's the kind of danger that she was in. We also applied cell tower engineering in this case, and was able to track the defendant's movement throughout the city of San Francisco, where he actually he first contacted the victim and assaulted her at AT&T Park, then made his way to her home in the northwestern part of San Francisco, and eventually where he was caught, where he was hiding out in the Presidio area of San Francisco. He actually pled guilty. He was facing 10 years in state prison. And in this case, this individual, Mr. Gloistein, we had one brush with the law, and it was a case that was expunged, but he never really exhibited any kind of he never committed any kind of crime, and he had a pretty clean record. He actually was going to go to law school, but now he has a strike conviction for the threats to kill her, and he also has a felony stalking conviction. So he's not going to go to law school, and he's not going to be a lawyer, which is probably good for all of us. In this case, the thing that was strange, and the reason why I put it up here is that you're not always on these kind of cases. That sometimes you have to perceive the danger of the victim and weigh the balance of equities. In this case, the victim, after she found out how serious this was, she was pretty much recalcitrant. But in this case, I had to think about not just her, but the next, even if he's going to date her again, I had to think about that. And also you have to think about the fact that this guy is establishing a history of poor behavior or bad behavior, criminal behavior even, towards women, and he needs to be checked right now. And you cannot wait, and I couldn't wait until there was another victim for me to realize that he's a danger. So even though she was recalcitrant, we moved forward with the prosecution. And the strange thing is there was some gamesmanship here where the family of the defendant hired her an attorney. Luckily, we were able to use the evidence code to preempt any kind of attempt to get her not to want to press charges or not to want to cooperate with the district attorney's office. She was subpoenaed to come to court, and she did. She even wrote a letter to the judge at a bail hearing. And the irony of the letter that she wrote, I'm pretty much quoting her. She said that the defendant is not as dangerous to her when he's drinking than when he's sober. So that was a weird thing, and I said, look, listen to Your Honor, the defense attorney actually argued the letter for bail. I was like, hey, you're a judge. She said the defendant is not as dangerous when he's drinking as when he's sober. So there's still a level of danger when the defendant is sober, and that was obvious in this fact pattern. Understanding the law of stalking is essential to proving the case. Now, every state has different statutes, and I have a little slight cold, so please excuse me, clear my throat sometimes. Every state has different statutes. California is probably one of the toughest because we have a specific intent to cause fear element that has to go along with the behavior that causes fear. So, and I think that's a flaw in California. Some states have that specific intent as well. Some states do not. But that's something we have to deal with. Statutory comparison. Basically, in general, there's a purposeful course of conduct. You have fear on the part of victims, and you have an intent to cause that fear on the part of offenders. For every statute, no matter what state you're in, you have these essential elements. The course of conduct. There's a pattern of behavior. How many acts? It just takes two. You can have one instance that has multiple acts, meaning going by the traditional stalker, hiding behind the tree, trying to voyeur the victim, calling. I've had one of those kind of cases where the victim was walking her dog. The defendant called the victim and said, nice pajamas when she walked her dog in her pajamas. Pretty scary moment for the victim, and definitely worthy of criminal prosecution. That's from. You only hear about that stuff from movies. Within a certain time period, doesn't matter. It can extend. Obviously, if you have one instance in a year, it's probably not going to rise to something that's criminal. But when you have multiple acts in a week or 2 weeks, it's important for law enforcement to put the clamp down, basically, and stop the conduct. It's important for victims to report to someone, to tell someone what's going on, or to even seek a restraining order. The main point is that all the acts have a similar or a continuity of purpose, meaning the purpose of all the acts is to gain attention by any means necessary. Basically, the defendant or the stalker is trying to do whatever that person can do, use whatever leverage he can use in the realm of fear to gain the attention of the victim. And even a moment's attention is worthy of all the acts that they do. So, for instance, when I had a case about similar to around the time of Palomo, the People versus Palomo case, where the defendant called for over a year, almost every day, filling up I think for 6 months, he filled up her voicemail all the time. Finally, she called, she answered the phone one time and said, "Stop calling me. I'm not answering your phone." And then he called back and acted like they had he said, "I wasn't able to finish our conversation. Can we please talk again?" So you can see that his delusion about his effort to call her and her answering the phone actually created gave him more energy, or actually energized him to actually keep on calling her because he thought his purpose was effective, or the purpose that he had to gain her attention had become a positive thing for him. Fear. Fear obviously is an element. The purpose of the stalking is to cause fear to gain attention. Fear of what? Serious bodily injury, obviously, death or sexual assault, fear for safety, fear of a loved one being hurt, a pet. And in San Francisco, as many of you know, if you harm an animal in San Francisco, no matter what the case or the fact pattern, it's not going to be a good thing for you because the animal activists in San Francisco, sometimes you actually have people that actually care more about the dog or the cat than they do about the actual person, which is not is understandable, but obviously human beings' lives are worth or something at least. What is required for victims' fear? It's a objective standard, okay? And this is what I tell jurors, and this is what sometimes I tell attorneys to ask jurors, or ask them to ask jurors, is if you under similar circumstances, when faced with similar circumstances, meaning when faced with the same fact pattern of person A doing this to person B, would the objective person or the reasonable, prudent person of ordinary means, would that person experience the same type of fear than this victim? That this victim experienced. So that's the reasonable person standard. They can be actual, and in some jurisdictions you have to prove actual fear. In some jurisdictions, all you have to prove, like in California, you don't have to prove actual fear, but in California you have to prove that there was an intent to cause fear. Not a problem. Sorry, I just had my supervisor come in. Intent. In some jurisdictions, I talked about intent. General intent, state must prove that the stalker intended to commit the actions that he is engaging in. That's it. That the defendant did the act which caused the person fear. Did not have to prove that he intended the consequences of the fear. And as a matter of fact, even in specific intent states where there's a specific intent to cause fear by your actions, not just by what you say. Because stalking can be an amalgamation of threats alone and then threats and conduct together. So the state does not have to prove in general intent that the stalker intended the consequences of those actions. So even in specific intent, I don't have to prove that if there's a threat to kill, I don't have to prove that the stalker tried to kill. Just that there's a threat to kill and that the reasonable person under those circumstances understood that threat and understood the consequences or appreciated the consequences of that threat, meaning they called the police for some reason. Even if that person said they weren't scared at some point or another, or they didn't really think that he was going to do the things that he claimed he was going to do, there's a reason why you call the police. There's some kind of, and sometimes you have to get that out of the stalking victims. A lot of people don't appreciate threats that are made by people who are intent on stalking behavior. And we're still at that stage with the crime of stalking, where it's a lot of people don't recognize it as an extremely serious and dire crime, because obviously they don't take these kind of trainings, by the way, and also they don't look at the statistics and look at the homicides where victims or intimate partner homicides where there's female victims and sometimes male victims, but in these intimate partner homicides, there's a lot of stalking. Well, I mean, we show the statistics. Stalking is statistically one of the primary prologue. It's the primary prologue for the homicides. Specific intent: the state must prove that the defendant specifically intended to cause intended to cause fear. And that is shown through a course of conduct, is shown through words, shown through letters, or a combination of all that. And it doesn't necessarily have to be words. It can just be a course of conduct. So literally, you can prove stalking without words, just by a person's presence. And what that presence means, and in the beginning, the first slide I think Michelle put up there is context is critical, or it had something to do with context. Context is everything when it comes to the crime of stalking and also just the colloquial stalking behavior. Context tells you how dangerous the stalker is to the victim, and context tells you the amount of intervention that is necessary in order to stop the stalking, keep the victim safe, and hold the offender accountable to stop that stalking behavior. Charging stalking. There's several advantages to charging stalking in multiple jurisdictions. One of the advantages is when you have to prove fear, and you ask that question, why are you afraid? When you ask the victim, why are you afraid, everything that makes that victim afraid comes in to evidence without need for any kind of evidence code. That includes prior bad acts. That includes prior convictions, depending on the context, obviously. If the victim knows that the defendant assaulted or sexually assaulted a prior intimate partner, and that has something to do with fear, that's going to come into evidence. And that's going to weigh in on the jury on factors of charging, and also going to weigh in on factors of holding the defendant accountable by trial by jury. So basically, the state can introduce evidence that would otherwise be inadmissible or would be subject to judicial discretion. And viewed in context, the stalking statutes can criminalize those even benign behaviors. For instance, if a victim says she was at a restaurant and the defendant walked by, and that somehow now ordinarily, or maybe that might be benign, but to the victim, the odds of that person walking by a restaurant where they're at would seem weird to them, because this is a person that they want to stay away from. There's no reason why they've never seen that person before at a restaurant when they're out, and all of a sudden that person's there. So basically, when properly investigated and charged aggressively, stalking cases literally can save lives. And it's very important to stay aggressive with the stalkers, because even in the course of criminal cases, normally on our criminal cases, stalking, the crime is over when we charge it. In stalking cases, it's still going on. There's still an attempt to contact the victim, even as stalking cases are ongoing. And most of you answered that question false when Michelle put that slide up. Do protective orders essentially stop stalkers? Well, most of you answered that false, and the reason why you did that is because this is an ongoing behavior. It's not something that's just going to stop once there's a criminal charge. Now, holding them accountable it means criminal conviction, a stronger restraining order, or even incarceration.
Hey, Mark, can I ask you a question here?
Absolutely.
So if you have a case where you have an offender, as part of their pattern of behavior, has violated a protection order, do you typically co-charge stalking as well? So will you charge the offender for the violation of the protection order and stalking if the behavior meets the elements of the stalking crime?
Absolutely, because it helps the jury, or helps the court understand the seriousness of the charge, and also gives me a chance to, if the jury or the judge does not understand stalking, or maybe the jury doesn't find that there was an intent to cause fear, at least there's a per se violation of the restraining order. So that's the lesser that I could get, because I can at least get a restraining order violation, which is what mostly is charged anyway. But I'm going to go for stalking because in cases where there's multiple violations, because there's a higher penalty and a higher ability to hold the offender accountable, and also explain the behavior as to why there's a violation of the restraining order.
And do you find that often these cases will get pled out, and so it's advantageous to pile on as many charges as you possibly can?
In some cases, that's a case-by-case judgment call. In some cases, you want to keep it simple. You want to go stalking. That's it. I'm going to charge stalking. And in some jurisdictions, you only have stalking. You don't have a restraining order, so you have to just charge one time period stalking. In some cases where you have restraining order violations, you'll charge stalking, and maybe I won't. Maybe I'll just do one restraining order violation because on that date there was something very significant that occurred. That's a part of the stalking process. So it just depends, because I don't want the judge to limit my evidence, so I try to put as much in the charging document as possible so that I have to prove it, and it's not subject to judicial discretion whether it should be admissible or inadmissible.
Thank you.
I think I just covered that. Like I said before, context is key. It should be included in the complaint as much, stalking on a certain date or between certain dates. The dates are important. Obviously, you don't have to charge every single date in most stalking complaints. You can just charge a time period, but including all of that time period. And this actually happened in a case for me where it wasn't clear when stalking started, and it's very important because I got all the way to trial, and the victim basically changed the time period where the stalking started. The stalking was real, and she was really being stalked, but there was some intimacy within the time frame I originally charged the case, and I didn't find that out till jury trial that basically the stalking started after that part. So it's really important to just get the dates narrowed down, and to talk to your victim about it when absolutely they didn't want any contact with the defendant. I actually have to run the court right now, so I'm going to turn this back over to Michelle.
Great. Thanks so much, Marc.
Thank you very much. Thank you all for joining the webinar, and it's been an honor. Thank you.
So we just want to end with just a few additional considerations for how prosecutors can assist victims in addition to prosecuting these crimes where there are repeated protective order violations and looking at how you can also charge this as stalking. We believe, and Marc and I talked about this, that prosecutors can also play an additional role in helping enhance victim safety by either doing risk assessment with victims or connecting victims with folks who can do risk assessment, such as law enforcement or advocates who've been trained in risk or threat assessment, working with them on safety planning, or at least encouraging victims to engage in safety planning, again with an advocate, is always helpful. And so then connecting victims with those advocates, whether they're system-based advocates, so advocates who are in the prosecutor's office or in the police departments, or community-based advocates at local domestic violence or sexual assault programs or victim services agencies. Unfortunately, there's very few communities in the United States currently who have dedicated stalking services or services for stalking victims, but we are finding more and more that stalking victims can access these services through places like domestic violence programs, sexual assault programs, or other victim services programs. That prosecutors encourage victims to document the stalking behavior, so it's really critical in building these cases that there's documentation of what's been happening, when it's been happening, maintaining evidence like text messages and emails. The Stalking Resource Center actually has a very simple and easy to use stalking documentation log that's available for download from our website that can be used by victims to document what's been happening, and also to ensure that there are support systems in place for victims. As we've talked about throughout this session, stalking is a crime that can last for a very, very long period of time. And moving through the criminal justice system, these cases can often take quite some time. And so it's really critical that victims feel supported or have a support network throughout that so that they can remain engaged and try and minimize some of the frustration that we often hear from victims as they wait patiently and sometimes not so patiently for their cases to move through the criminal justice system. So prosecutors can play really, really critical roles beyond simply prosecuting the crimes. And the point that we wanted to end on is just really emphasizing what we've talked about throughout this session, that successful intervention and prevention can prevent more serious things from happening. Without it, the results may be that we end up with more dangerous predators and higher risks to the victims that we're all working with. So I want to thank you. I want to echo what Marc said. I want to thank you again for the opportunity to talk with you today. We have additional resources related to stalking for both victims and for professionals who are working with stalking victims on our website, which is the www.ncvc.org/SRC. Please take an opportunity to check out our website. If you have any additional questions or cases that you're working on that you're looking for additional information or assistance, our contact information is there as well. And I will turn it back over to Sarah.
Thanks, Michelle. Thank you all for joining NCPO FFC for the Stalking and Protection Orders webinar. Allow me to introduce today's speakers. Ms. Garcia joined the Stalking Resource Center for Victims of Crime in April of 2006 and has served as their director since October of 2006. The mission of the Stalking Resource Center is to enhance the ability of professionals, organizations, and systems to effectively respond to stalking. Ms. Garcia was a program specialist with the U.S. Department of Justice Office on Victims of Crime previously, and she has 20 years' experience working with victims of stalking, sexual assault, and domestic violence in both rural and urban settings. Mr. Guillory is a felony prosecutor for the City and County of San Francisco. He prosecutes serious and violent gang-related cases and high-profile general felony crimes. He began his career as Deputy District Attorney for the County of San Bernardino. He is a former lead domestic violence prosecutor for the Central District of San Bernardino County and has prosecuted felony and domestic violence and stalking-related felonies for the City and County of San Francisco. The Stalking and Protection Orders webinar is the second to last webinar in a series of webinars and teleconferences offered by NCPO-FFC. NCPO-FFC is an OVW-funded technical assistance provider in the areas of protection orders, interjurisdictional enforcement of protection orders, and federal and state firearms prohibitions as they relate to domestic violence. NCPO-FFC has several publications on protection orders and full faith and credit, as well as statutory matrices on a variety of laws. These items are available free of charge. This concludes today's presentation on stalking and protection orders. Please visit the NCPO-FFC website for additional information. Thank you so much and have a pleasant afternoon.